Hi, thank you for joining this webinar that's hosted by the National Governors Association's Water Policy Learning Network that operates under the Center for Best Practices. I'm Bevan Buchheister, and I'll be your moderator for today. I'm a senior policy analyst at the National Governors Association. The webinar today will focus on the benefits states can achieve, challenges they will face, and specific action they must take and criteria they must meet if they want to assume authority from the federal government for filling and dredging wetlands, for permitting the fill and dredge of wetlands. And more specifically, that's the Section 404 of the Clean Water Act. 2 states currently have authority, and several other states are interested. So that's why we are running this webinar. Our first speaker is Trevor Bajore. He's the director of the Water Quality Division for the Arizona Department of Environmental Quality. He's a native of Arizona and a 2-time graduate of Arizona State University with a bachelor's in chemical engineering and a master's in business administration. He's been advocating for Arizona's environment since 2001. His main focus at the Department of Environmental Quality has been air quality, but he's been learning the world of water since 2014. He's registered in Arizona as a professional engineer and is a champion of Arizona DEQ's efforts to deliver faster, better, cheaper government. Trevor will be speaking from the perspective of a state that does not currently have a parallel wetlands permitting program. Our second speaker is John Truitt, and John is the Deputy Secretary for Regulatory Programs at Florida's Department of Environmental Protection. He provides oversight and direction to DEP's 5 regulatory divisions: air resource management, water resource management, waste management, Florida Geological Survey, and Office of Emergency Response, along with 6 regulatory district offices. The regulatory programs carry out DEP's role in permitting facilities like manufacturing and power plants and assisting them with compliance. And John will be speaking to us today from the perspective of a state that currently has a parallel permitting program for dredging and filling wetlands. And before I begin, I have a few announcements for our listeners. I just wanted to let you all know the webinar will be recorded, and the GoToWebinar will email you a link to the recording tomorrow, so you can share that with your colleagues or listen to it later. And I also wanted to let you know that John Truitt has provided a handout, which is a briefing document of this issue, and the Florida House bill that allows for assumption of the federal program. And I think that's in the works now, and I'll let John expound on that. And you can find that handout on the Handouts tab in the box on the right-hand side of your page. So if you click that Handout tab and click on the document, those 2 things are in one document, and you can download it during the webinar. I also wanted to let you know that we are taking written-only questions on this webinar, and we're going to pose them to both of our speakers at the end of the webinar, since the 2 presentations build on each other. So for questions, you just type them in the questions box on the control panel anytime during the presentation. There's an option to send your question privately, or you can send it for everybody else to see, and I will pose them all to the speakers at the end of the webinar. So I'm going to hand it over to Trevor and let him begin his presentation.
Thank you, Bevan. I appreciate the introduction. I absolutely have been advocating for Arizona's environment for almost 17 years now, and so water quality is one of those topics that I love to talk about these days. So I'd like to give, as we start, a little bit of context about the 404 program, just to make sure everybody understands. Arizona's belief is that Congress did not intend for the Section 404 permitting program to be run by the Corps of Engineers or by EPA on a nationwide scale. It is the policy, and my understanding of what Congress intended was that states, very similar to the NIPD's 402 permitting program, that states would take on the 404 permitting program. And I'll get into a little bit as to why that may not have happened and some of the obstacles that are out there with trying to get that authority. So I'd like to explain a little bit about where Arizona is today. Arizona does already have the NIPD's permitting, the monitoring and assessment, and all of the other components of the Clean Water Act that are assumable. The only one we're missing right now is the 404 permitting program. I should note that Arizona, probably because it's a very arid state, has not developed any type of state-driven wetlands program or dredge and fill program, even similar to the 404 program, which means that the Corps has historically run this program in Arizona. And that's important just because we don't have a state program that we're trying to push through as the regulations for the Clean Water Act. We have to start from the beginning. So again, a little bit of ecosystem. 404 primacy has several facets to it. The 404 program is a permitting program specifically to make sure that the waters of the U.S. that are regulated under the program are protected. So there's a permitting component. So the state wanting to assume the program will have to have permitting authority, also enforcement authority. As with any permitting program, the program needs to be able to define who is regulated and who is not. And that's really what jurisdictional determinations do. So that's another piece that will need to go into the primacy package when we're looking for, when we eventually get to submittal. And then there's a biological and human welfare review, which we'll talk a little bit more in my presentation. And finally, there's an agreement with the Corps and with EPA that has to go into primacy too. The agreement with the Corps is mostly about what waters the state will be regulating and which waters the Corps will retain authority over. And I actually had an opportunity to be on a NACEP subcommittee specifically about that topic, and we'll talk a little bit more about that in my presentation. And then the agreement with EPA, the memorandum of agreement, really covers things like what permits they're going to review, what's the interaction of the state going to be, and how we're going to work together. So where is Arizona today? Because we don't have an existing state program, we are currently seeking statutory authority for the Section 404 program. And so that bill, which was introduced this legislative session earlier this year in Arizona, is currently making its way through the process. It has passed the state Senate and is currently going to be heard soon in the state House. The legislation, the introduced legislation, is really about giving ADEQ the structure for establishing this program. It is just laying the groundwork. We expect that there will be a robust stakeholder process as we try to identify and come to agreement on the details of the program. We absolutely need the voice of the customer and the voice of our stakeholders to make sure that we design the program in a way that's going to be beneficial for Arizona, as well as meet the requirements of the Clean Water Act. Once we have that stakeholder process, we will then actually start our actual rule writing and program development. Rule writing, of course, will be the regulations that are going to be implemented, but we also have to make sure we have the technical expertise and the staff on board to be able to run this program. Once all of that is in place, we will then submit the program to EPA for approval. Again, there's voice of the customer and voice of stakeholders all throughout all of these processes. Our estimate at this point is that the earliest we would be able to submit any type of package to EPA would be in the middle of 2019. So we're looking, since we started this last year, at least a 2-year process for trying to get a package submitted and then approved by EPA. So I wanted to cover a little bit of why now. Why is now the right time for Arizona to pursue primacy over the 404 program? One of, I think, the key pieces is that the current EPA administration that we have has restarted the conversation about how states and the federal government interact with each other. They have come out and specifically said that states should look into obtaining these programs, and they want to delegate these programs to states and give them the opportunity to run as Congress intended. So there's a couple of other pieces that have aligned for Arizona as well. One, there is a state push. Customers for the state have recognized that there could be some benefit to them for getting this program. And also the agency, the maturity of ADEQ is finally to the point where we believe that we could run the program effectively and bring value to our customers. We did try to seek primacy one other time in 2011 or 2012 timeframes. the agency wasn't ready to take on that program yet, and we believe now that we've reached a maturity level that will give us that opportunity. One of the reasons we believe that, if you look at the graph on the left, the department has begun its journey to maximize customer value and environmental protection and eliminate waste out of our programs. The graph on the left shows that between 2008 and 2012, every permit issued by the department took an average of 144 days to get out. And that includes things like general permits and individual permits. And you can see over the past 5 years, we have made huge progress in reducing the waste in our permitting programs, still able to issue environmentally protective permits, but do it in a way that gets that environmental protection out faster. The one thing I will note about this data is that while we have gotten a 66% reduction from our baseline in 2008-2012, we've also stopped counting permits that issue in the same day. So we have automated several of our permitting processes to where they're same-day issuance. And so that data is in the baseline. Those short-term permits where they used to take us 20 to 50 days are in the baseline. We don't even count those now. So it's a real reduction in permitting timeframes that we're talking about. We believe that maturity, that demonstration that we can meet the customer's needs in a better way than we ever have before is one of the reasons that 404 is of interest to us, because we believe that we can issue 404 permits faster than currently is being done. I've talked a little bit also about local control and cooperative federalism. The perspective of many of our stakeholders and customers is that 404 at its core, it becomes an urban planning process. And that is really something that is better done on the local level, not at a federal level. I absolutely will advocate that we can provide better customer service to our customers. But here's the key thing that's important to realize. As we go through the process and as we go through the effort to obtain the 404 permitting program, if our customers at any point feel that they are not going to get value out of the state taking over this program, then we shouldn't do it. The whole purpose here is that, our Arizona's 404 permitting program has to remain just as stringent and consistent as the federal program. So it's really about customer service and customer value. And if we can't provide more value to customers than the current process is, then it's not worth ADEQ pursuing that program. For us, independent of customers for a minute, alignment of the Clean Water Act programs is key. We have to make sure that as interpretations of waters of the U.S. And our focus on waters that we're trying to help improve, we need to be able to align all of our programs, including the 404 program. And we'll talk a little bit more about costs, but we believe that we can reduce the life cycle costs for customers as they try to obtain these permits. So those are some ecosystem issues as to why why Arizona is pursuing this program now. I'd like to get into a little bit about what are the hurdles that we've come across, what are the challenges that we've faced. Overarching concern of ours is that the current rules and Clean Water Act structure is not designed to give states the same standing with EPA that the Army Corps of Engineers has. So a couple small examples. States can only issue permits for 5 years, where Corps could issue permits for a longer time period. EPA can object to Corps permits, but can't stop the permits from being issued, whereas with the state program, the Corps or the EPA, if they object, it absolutely precludes the state from issuing that permit. So there is not an equivalent footing for the federal to state relationship that there is for a federal to federal relationship. My observation over my 17 years as a DEQ employee is that oftentimes the federal agencies enjoy a sister agency relationship, whereas with the federal government and states, it's often felt more like a parent-child relationship. And that's what one of the hurdles that we've come across. There's another couple hurdles that are shown on here, and I'll get a little bit deeper into the Endangered Species Act component. And I know John will cover this probably in a little bit more detail. the challenge for states in trying to obtain the 404 program is that the state does not have the benefit of using the same consultation and coordination processes that the Corps does, specifically Section 106 of the National Historic Preservation Act, Section 7 of the Endangered Species Act, and the Fish and Wildlife Coordination Act. And so specifically on ESA, the challenge becomes that because states can't use the Section 7 consultation process through our state 404 permitting program, entities or facilities that need a 404 permit, if they have to, if there's an endangered species of concern on their property, they then have to use a Section 10 process under the Endangered Species Act. And Section 10 is generally known as a much less streamlined process than Section 7. The planning process is long and cumbersome for permittees. And so that puts state programs at a disadvantage, even just taking over the program, because permittees now have a separate permit that they would have to go get under Section 10 as opposed to the consultation process under Section 7. But that footing aside, this program, the 404 permitting program, is a 45-year-old federal program that still creates confusion for permittees. And so the challenge for states trying to assume is that if there's confusion about the 45-year-old process, how do states try to come in and take over that confusing process and add clarity to it? So as you can see by the quote, aesthetics, recreation, the needs and welfare of people, these start to become urban planning issues that the 404 program creates confusion and creates a regulation around. Some of the overarching challenges with trying to assume the program is, first, you have the waters of the U.S. definition. Here we are 10, 12 years after some Supreme Court decisions, and there's still lack of clarity regarding which waters are regulated under the Clean Water Act and which ones are not. In Arizona, that especially becomes the case where we're a state that doesn't have a lot of perennial waters. We do have a few, and then we have some intermittent, but the majority of our waterways are ephemeral. And how does the Clean Water Act manage the fact that these ephemeral washes may only have water 5 or 6 days, or maybe 20 days out of the year? I mentioned that I had the privilege of being on a subcommittee trying to determine what waters are assumable by the states and which ones are not. There's significant disagreement among the subcommittee of which waters can be obtained. So that's critical for states to know that, because a lot of that will determine if a state can only take over a few waters, it may not be worth the state having its own program, and it may be worthwhile to just let the federal government continue to run it. There's also obviously lack of precedence. There has not been a lot of states that have assumed the program, and so because of that, there's confusion about how you do it. One of the other hurdles that we have come across, and is a fairly well-recognized issue, is that there is no federal funding for the 404 program. We have, as a department, determined that we will likely have a fee-for-service model where entities or people wanting to obtain a permit would have to come and pay for that straight to the department. And so that's a concern of many of our stakeholders. Ultimately, the costs associated with the program are going to be significant. It's going to be, it's not a small program. There'll be lots of costs associated with it. Another overarching category of problems that we have come across is the lack of broad expertise on 404. Historically, ADQ, as I mentioned, ADQ has not run the program, so the Corps of Engineers has run the program, and they have a local office here in Arizona, and they have been very helpful, very willing to work with us and given us information that we've looked for. But the challenge is that because we have not historically coordinated well, there is a lack of knowledge of the 404 program at the state level. The state, our ADEQ and state organizations don't have a lot of knowledge about the 404 program. EPA regional office here in Arizona, Region 9, doesn't have any expertise associated with the 404 permitting program because there's never been a Region 9 state that's assumed it. Headquarters folks are fantastic, but again, the lack of precedence, the lack of flow of states trying to obtain the program hampers a bit the consultation, the recommendations that they can make to states. And finally, the Corps. I mean, the Corps has been running it on their own, but they don't really have a lot of insight of how to transfer this program to a state as well. We've also had, as we've watched how this program is going to unfold, there are a lot of individual agencies that are going to be involved in this. And some of these agencies, DEQ does not have, or Arizona does not have a very strong relationship with, simply because we have not interacted with them before. And because of that, as we work to establish those relationships, each of these agencies has their own mission, they have their own opinions and processes, and we'll have to have strong relationships with them as we try to implement this program. Finally, as far as hurdles go, there is a huge breadth of stakeholder interests associated with the 404 program. There is what ADEQ, what Arizona did is we felt that, you know what, we're going to have a little bit of stakeholder meetings, then we're just going to get our legislation that gives us the authority to get this program, and then we're going to go talk to everybody about how this program is going to be implemented. We learned from that really the conversation with stakeholders and kind of the direction for the program is probably more important to get ahead of time before you even worry about legislation, so that people, those who interact and have an interest in the 404 program, understand what the state's going to do. Because I think the biggest challenge that we have faced is that when we get stakeholders coming in with questions, we don't have ready answers for those questions or the direction we're going to take, because our intent was to discuss those as we implemented the program. One key piece I should note about our legislation is is not a directive legislation. It's ADEQ may adopt rules and regulations for purposes of getting primacy over the 404 program. We put it as a may specifically because that way, should we decide as we're implementing the program that we're not going to be able to provide customer value, that we will then stop and not be in violation of state law as we do that. Just a couple of things that I'll highlight as far as the concerns that we have heard. There's lots of logistical issues. I mentioned that we were going for a fee-for-service model. Governmental or non-governmental organizations have concerns with fee-for-service models, and so that's been something that we've had to talk about. We've had questions on the crushing cost of litigation that might be associated with 404 permitting, how we're going to make sure that customers still get to prioritize which permits get worked on first, those kind of things, how much public process there's going to be, and how are we going to handle our relationship with EPA. So finally, here are some DEQ recommendations that if we're going to meet the intent of Congress, if we're going to be able to meet the congressional intent that states take over the 404 permitting program, we need some changes. And so here's a list of a couple of those. One, we need to empower states with funding and usable rules. We need to understand what the criteria are for obtaining primacy over the program. The phrase consistent with the act needs to be clarified, given some guidance with regards to what steps we can take to make sure that whatever program we're offering is consistent with the act. We need to increase state and EPA assumption knowledge. We need to have regular dialogues so that states can clearly understand the regulatory structure of the Clean Water Act and what efforts need to be made or what paths need to be cut in order to get primacy. And then finally, we need to equalize the state and core 404 programs in the Clean Water Act. Ultimately, if states are going to take this over, the relationship between states and the federal government needs to be the same as the federal government has relationships between its own agencies. So with that, that is my presentation. Ultimately, Arizona will continue moving forward towards primacy, and we look forward to the expertise of some of the other states that are a little bit further ahead of us, like the state of Florida.
All right, and we're going to turn it over now to John Truitt. Thank you, Trevor. So John is the Deputy Secretary for Regulatory Programs at Florida's Department of Environmental Protection. And so John, please begin.
Okay, thank you, Bevan. I guess two things I'll cover preliminarily. We're coming at it from a different perspective. We already have a state wetland program. It's called our Environmental Resource Permit Program. And we're unique in that our state program actually covers far more areas in the state of Florida than 404 does. So for anyone that is currently getting 404 permits, you're already coming to us to get an ERP permit. So we're approaching it from that perspective, looking at how much duplication is already in existence. And you know, when we look at it, we saw the 404 B1 guidelines saw an 80 to 85% overlap in a lot of the requirements. So it was a true issue of duplication in the state of Florida. And so that's why we looked at assuming it for efficiency's sake. It's been looked at from the state of Florida before. There's been different approaches. Previously, Florida attempted to go to the EPA and take our state program and say ERP is a substitute for 404, and that didn't really work. So the approach we're taking this time is we're asking our legislature to pass a bill, which is in your handout, and I can touch that in a minute, to give us the authority to bring down any of the federal regulations that would be additional of those that we already have built into our state system. And so that goes to the handout that Bevan had mentioned at the beginning. So what you all have in that is the first page is kind of the in-depth review of why it's beneficial. The second page is the talking points on what the bill does. The third page actually outlines a difference between the state permitting time for our ERP permits and the permitting time that the Corps is running for the Section 404 permits for state-led restoration projects. We have very large sums of money dedicated to restoring wetlands in the state of Florida. Obviously, Everglades might come to everybody's mind, but there's plenty of others. And so we have a disconnect in terms of the legislatively appropriated funding and when it can get done based on some of the lengthy timetables we see in the 404 process. And then the last thing in that handout is the copy of the House bill. It's passed off our House floor. It's gone through all the Senate committees unanimously. It should be taken up, I think, on the Senate floor tomorrow and passed without issue. I'm speaking optimistically because our legislative session ends next week at the end of the week, but so far it's moving smoothly. So when we looked at, like I said, with our already comprehensive wetland permitting program, we approached it differently. We have a lot of the experience and everything else, so we were coming at it from the perspective of what do we already do and what do we have to add? And so that really gets to the point of, you know, what's the relevant law? And it's fairly clear if you'll look at 33 U.S.C. 1344 and the Code of Federal Regulations. You know, they lay out fairly straightforward the criteria for the state assumption. One thing I would flag is there's a waters definition difference in 404 G1, West Coast versus East Coast. So that is obviously something to consider. And then also you will need to look at Section 10 of the Rivers and Harbors Act to understand the overlap and interplay with Section 10 and Section 404 if you look at this, because Section 10 plays a point in looking at what waters the state is not going to get. 40 CFR Part 233, very detailed in terms of what you have to put together, very detailed in terms of the procedure. And the key thing is it may not impose any less stringent requirements for any purpose. That is a common issue that comes up. We've heard that from all stakeholders, both sides of the aisle, etc. What happens if the feds change and you've assumed? Well, if the feds become more stringent, you're going to have to go up and meet them. If the feds go down, you don't have to change, like other assumed programs. But that's a big concern in the stakeholder community. So looking at, my apologies, looking at what you're going to get, it's easier to ask what you don't obtain the way the definition is worded. The definition doesn't quite follow WOTUS, but it says a state can get the 404 program in the navigable waters other than those waters that are presently used or are susceptible to use in their natural condition or by reasonable improvement as a means to transport interstate or foreign commerce, and then it includes ebb and flow of the water. So it's very clear in the United States Code what waters are retained. Now, if you start to dig into the Code of Federal Regulations and look at navigable waters, that's where some of this disconnect can occur in terms of what should remain with the Corps and what can come to the state. So me flagging this on the front end, I think, at least in our experience and some of the other states we've talked to, this is one of those overarching threshold questions, and Trevor mentioned it as well, to look at. Is it really worthwhile? And it involves a conversation between the state, the EPA, and the Corps. The regulations require that in your memorandum of agreement with the Corps, you have to list the waters that stay under the Corps jurisdiction. What we've done in the state of Florida is many Corps district offices have navigable waters lists that are published. Some of them have flexible lists that are not as final as you would hope, so there may be a lot more homework on the front end if you look at a program like this. We have a very good GIS mapping team, so that was one of our priorities when we started heavily looking at this last summer, was trying to get this on a map so we can see exactly and show people, because everybody wants to understand, is this worth the lift? And then you get to the subcommittee that Trevor had mentioned, and we are proposing the majority opinion of the subcommittee, which is essentially the navigable and fact waters plus a 300-foot administrative buffer. We have a lot of wetlands in the state of Florida. It would almost be physically impossible to go out and literally map the wetland delineation line all around the state. So the administrative buffer is what helps make the 404 delegation actually work. Our existing state permitting program, our state level wetland delineation would create a line that is at least equal to the Corps and quite often farther upland. So that's what we're in discussions with to show the EPA in terms of at least as stringent as, is our already existing methodology would cover at least what the Corps would say. So if you do have a wetland permitting program in existence, I would recommend you start that conversation early as well. So this goes to, if you have a wetland permitting program in place, again, how much area is it going to cover? What kind of technical experts do you have? Do you have those experts that overlap some of the Corps' 404B run requirements? Are you going to have to learn new fields? Are you going to have to bring new experts in? A big issue, as Trevor mentioned, is without the federal funding, what application fees can you charge? What we're looking at in the state of Florida is we already have an application fee for our ERP permitting program, and given the number of 404s permits that come in, as an example, in a fiscal year, there was 162 individual 404 permits issued by the Corps. In that same fiscal year, the state issued 7,300 and some odd ERP permits. And as I mentioned at the beginning, if you're getting a 404, you're getting an ERP. So we're already looking at all those projects. So that's why we believe we're just going to absorb it in our existing structure and not add an additional fee related to the 404 itself. So that was a big plus for us, not starting with nothing, but already starting in a system that 404 is really a subset of our existing regulatory universe. It's a lot easier for us to absorb that. And that is the big question, though, is the funding, because if you do, I know with our state laws, the state legislature has to specifically state in law what an application fee can be. So if you're looking at legislation to go down the avenue, obviously you have to figure out those potential costs far ahead of time before you go through rulemaking and everything else and submit a package and then realize you're going to need more funding later on. So this is kind of the process about how we did when we looked at it. So we took our state regulations and matched them against the 404 regulations, and I would suggest engage EPA as early as humanly possible in the process. You obviously need to engage the Corps, but the interesting thing is the EPA is the decision maker on the assumption package, even though the Corps is the implementer of the current 404 program. So depending on how in your area your regional EPA office works with your district Corps office, there may be some getting up to speed between the two of them that may be necessary. Some states that I've talked to have said their statutory authority in existence they believe is already broad enough. Florida, we have pretty strict requirements in terms of rulemaking authority, etc. So, like I mentioned in the handout, there's the bill that clearly gives us the authority to go forth. Like Arizona's, it's not a must, it's a may. If we get to a point where either we find something that's unworkable or it's determined that it's not worth it, we don't have to. I would recommend, if you're looking at the bill language, engage the EPA early. They have directive from DC on down that they're really looking at getting these assumable programs out. They want to get this power to the states. It clearly seemed to be the intent of the drafters to ensure that states have the ability to do this. And we've found in Region 4 here that they've been excellent to work with all the way at the beginning, looking at even proposed bill language to address any concerns in our discussions that they may see if there's a potential shortcoming in state law or certain exemptions. A big thing we had in the state of Florida was state exemptions versus federal exemptions. So existing use ag or future use ag. We have a disconnect between our state and federal law. We have the NPDES program, so we literally lifted some statutory provisions from that, the exact same language, to clarify the federal exemption, state exemption dichotomy to make sure that, one, we weren't reinventing the wheel and creating a potential legal challenge with new statutory language, but two, using something that not only is tried and tested, but everybody's used to. And then what we've worked with EPA is creating something that we're calling a crosswalk, which is we take all of our state regulations and put them down with the federal regulations on a chart and just match up as much as you possibly can, so you can get that idea of, if you need to adopt additional, what is it? What we did in our bill was we proposed, you'll see the language, we called out a few sections by citation. We called out the 404B1 guidelines by citation. We also called out the public interest review criteria that the Corps uses by citation. But we also did the catch-all broad language such that we won't be stuck in a box if we need to adopt something we didn't think of at the time we drafted this last August. And then these are those things that we've kind of discovered going through the process. As Trevor mentioned, again, the outreach to the affected stakeholders, they're going to run the gamut in the state of Florida. Like I said, we have the state wetlands permitting program. On average, our overall, all the permits in the state of Florida, we average about 17 days a permit. And those are, good quality permits. We very, very rarely get overturned, probably a 99% rate, versus the 404 shooting somewhere between 200 and 300 days. So there's certain industry that wants to see it come to the state because they want to maximize the efficiency. There are other stakeholder groups that believe that the delay creates a better result. So it's reaching out to all of those different types of stakeholders to explain what the intent is. And our common refrain here, even in Florida, is we're not changing the 404 program you're used to. We're attempting to create the efficiencies and use the localized expertise because we believe we're more responsive to people's concerns in their own backyard than the Corps can be, given our location all throughout the state. And, we like the idea of the state managing its resources. You also need to look at that there's certain categories of review. Trevor briefly mentioned the veto power that EPA has. There's 6 of them that are in the Code of Federal Regulations. It flags threatened or endangered species, affecting other states, critical areas. It goes through historic areas, refuges, parks. So there's a number of those, and it would behoove you to look at those ahead of time, because depending on the size of your state and where you could get assumable waters, that might be a significant factor in determining on whether you want to do this. And then another big question is, what happens with all the existing 404 and all the pending applications? In the regulations, there's a condition called the clean break provision, which means that on the date of assumption, which is when the assumption is published in the Federal Register, everything in the pipeline switches to the state. So if you're in a scenario where you don't have a wetlands program like we do, and these projects will all be new, obviously you have a lot more work on the front end to do to set up to be able to account for that. And then in terms of the existing permits, and when they come to the state for a renewal versus going to the Corps, how are you going to set up that renewal process, transfer of case files, and information like that? And then there's also the wrinkle of pending enforcement actions. Again, all of this stuff can be worked out as long as you open the dialogue early. I can't stress that enough, because there will be items that people have not thought of. We still see new stuff almost every day. But if you have the dialogue open, I think it makes it a lot easier. So again, this is the overall picture of what I would suggest. Get with EPA early to work on bill language and the comparison of the regulation. Our Region 4 people have been fantastic working with us. We do every other week. They come down. We make regular trips to Atlanta. They have a dedicated team on it. We get with the Corps early to compare if you already have a wetland delineation method in your state, to see if it matches. If you don't, to learn how they do theirs. And then the map of the water is retained by the Corps. I know, many Corps offices have issues with funding or staffing, and that can lead to their delay times. So I would suggest extending an olive branch and offering to help wherever possible. And I'd also say engage the Fish and Wildlife Service and the National Marine Fisheries Service to address this Endangered Species Act implication. And Trevor touched on this, the Section 7, Section 10 issue. I'll go into a little more detail later, but you need to engage the services early, because one thing we discovered is they create maps of areas for the endangered and threatened species. And when they draw those polygons, sometimes they're not as precisely located as you would hope. And so we have areas where the National Marine Fisheries Service has a polygon for an endangered marine fish that goes beyond the 300-foot administrative boundary we've proposed upland. Clearly, the fish is not located there. However, the lack of precision on their polygons creates an issue when you're going to look at ESA implications down the road. Again, engage stakeholders early and often on their concerns. There's going to be lots of different varied groups that are going to want to weigh in. And what we've really worked on this time around is transparency. I've appeared in front of a bunch of committees, and I'll always say, if anybody wants to reach out to me and have a phone call or come meet in person and discuss it, I'm glad to hear. Some people may fall in the camp of just being distrustful of the state. Some people may fall in the camp, well, I'm comfortable with the Corps and I don't want to change. And then other people just want to understand how it's going to work and how they get input. We've had certain groups that were concerned about our legislation because they believed once the bill passed, then assumption was done and their universe was over. They had no more opportunities to engage. So they just didn't understand the process of the rulemaking, and the package goes up to the EPA, and the EPA puts it out for public comment and then makes a decision. And the fact that third-party citizen suits still remain, like in other delegated programs. There's just a lot of people that aren't familiar with it, because with the only 2 states that took it, I don't think it's broadly known how it works. So the Endangered Species Act was kind of probably the biggest hurdle that we're tackling, and it's the Section 7 versus Section 10 versus a hybrid. I put hybrid on there because if anyone wants to look, New Jersey, in their assumption, has a memorandum of agreement that they did with the Fish and Wildlife Service, EPA, and the state. And they tried to create something that looked similar to a consultation process, but put in more timelines, but it's not a true Section 7. So it would not grant the liability protections from Section 9 claims. And we do understand that clearly Section 10 world and going down that process to get a permit is very daunting compared to Section 7. So we've been working closely with EPA and our state Fish and Wildlife Service, and both us, the state, and the Fish and Wildlife Service here in Florida believe that we can remain in Section 7 world with state assumption, using a three-way memorandum of agreement whereby the state coordinates with Fish and Wildlife Service all the way up until the point a biological opinion is needed. If it's determined that one of those is needed with an incidental take statement, then that could be requested directly by the EPA from the Fish and Wildlife Service through our three-way memorandum of agreement. So if it winds up working out that way, and we can keep it in Section 7, which is our intent, and we're hopeful of that, we will certainly, if anyone's interested, can reach out to us, and we'll certainly hand that template over, because I do understand the concerns of not being able to stay in Section 7. Again, one of the other things we had is the assumable waters, the Clean Water Act definition versus the navigable waters definition you see in the CFR. We fall in the camp, like the majority opinion from the subcommittee, that the Clean Water Act is pretty clear on what it intends, and the much more thorough navigable waters definition in the CFR is probably not wholly applicable here, because it could render the ability of a state to assume something irrelevant. It negates so much that it doesn't make any sense to do it. We've also come up during the legislative process hearing a lot about NEPA. And as an assumed program, NEPA does not come down. However, you know, when you look at NEPA and you look at the different things that NEPA has to look at, what you'll actually find is if you look at the 404B1 guidelines in 40 CFR 230 and the public interest review criteria in 33 CFR 320.4, again, those sections, we flagged them in our bill, most of the NEPA things are covered in those requirements. And there was actually a Ninth Circuit case that actually said it best, which is what I've been quoting in front of our legislature. They said, quote, "The scenario serves to highlight the distinction between NEPA and the Clean Water Act. NEPA is procedural and simply not as demanding as the Clean Water Act on the issue of wetlands." And so I think from a substantive standpoint, the items that must be reviewed are already built into 404. So it really becomes an issue of educating people and making sure they're aware of that fact. Another issue we've also seen was requests from different groups for legislative ratification. They wanted us to submit a packet, have EPA say okay, and then come back to the legislature to ratify that. Per the procedure that Assumption works under, the EPA is not going to do anything with your packet if you have anything left to do with it. The state has to be completely finished, and then the EPA will send it out for comment, evaluate it, and make their decision. So that is a non-starter. And that goes back to, again, working with the stakeholder groups, explaining to them the legal process, and letting them know that you're trying to make it as transparent as possible. You know, we frequently have the meetings, and we'll take concerns that are raised to us, to the EPA team, get answers, come back to the groups and convey those answers. And that goes to my last big point, is education. 404 is unique. It's one of the few assumable programs where, for example, the Endangered Species Act, the EPA maintains mandatory review over. Only 2 states have done it, so there's not this large body of case law in terms of existence of how it works or how it should work. Those states were kind of unique. The states looking at it now all have their own idiosyncrasies, so everybody's kind of looking at it from a different angle. So it's really getting out there, not only with the stakeholders, but with our legislature, and educating them on what the process is, what 404 does, how we're already doing most of it. And that's all I had to discuss on it. But again, feel free to ever reach out to me if you'd like to ask any questions or particulars that my talk may have triggered. Thanks.
Thank you, John. And I just wanted to remind everybody, if they wanted to submit questions, that to do so in the question box. And I'll take the moderator's prerogative and ask the first question. John, you had mentioned the Endangered Species Act, and the state can't use the consultation and coordination process under Section 7. And so you need to use the Section 10 process. Can you elaborate a little bit more on the difference between Section 7 and Section 10? Does one of them give any more or less protection for endangered species?
Well, one of the issues is, the issue in terms of the Section 10 is it's a lengthier process with more things. The Habitat Conservation Plan, it involves much more work on the applicant side in terms of the process. In terms of protections, I don't know, I wouldn't go out on a limb and say that there's more protections under 10 versus 7. We have, I think, 122 listed species in the state of Florida. So one advantage we have in the state is that our Fish and Wildlife Service has developed a ton of things they call keys. And all of these keys indicate all these types of items that you would need to stick into permits to condition to avoid take issues. So we have a lot of the groundwork has been laid. I'm sure there are some areas of the country where that groundwork may not be there, and it may be more starting from scratch. But again, we're kind of well positioned to take advantage of a lot of previous work that's been done to step in and make it a lot easier for us. But I did want to clarify that the way we're doing it with our MOA is intending to keep it in the Section 7 world by using the biological opinion with an incidental take statement. However, we'd have to do a 3-way memorandum of agreement to do that because only a federal agency can receive a biological opinion. So what we would do is the state would work directly with FWS to include as many conditions as humanly possible and do all of the biological assessment and everything else up to the point that a biological opinion was needed. Should that be needed, then the EPA could formally request that. And then that way it would stay in the Section 7 to ensure that people had the liability protections the ESA can provide.
Okay, thanks. And so this question is for both John and Trevor. So what's your strategy for public outreach? How many meetings and where are they being held, and who are the major stakeholders?
John, you want to go first?
Yeah, I can go first. So we'll have, once we do the rulemaking in terms of those public meetings, I'm assuming we might have 3 located around the state, but what we'll wind up doing if the legislation passes is we'll wind up putting up a website. We actually get pretty good response here in the state of Florida related to websites. And so anyone can call and reach out. What we've had from these stakeholders reached out thus far, we have, there's a lot of big industry ag and mining groups, phosphate mining and agricultural groups, and they are approaching this from the perspective of they understand how 404 works now, so they just want to understand what's going to change in their universe. And then environmental groups, Sierra Club is one of the big ones, Audubon, and then we have some that are more state-specific, are falling in the realm of they're wanting to understand if the state has the expertise that the Corps has and whether efficiency or a faster permitting process will result in less environmental protections. Those are the overall groups that have been primarily engaged thus far. Has been, like I said, the industry and the environmental from what we've seen here.
And it's a similar situation in Arizona regarding the groups. I mean, mining, developers. We've also seen a lot of interest from some other government entities. So our Arizona Department of Transportation, they're one of the biggest users of the 404 program, as well as our game and fish folks. They're all stakeholders that, again, like Florida, very much want to know, hey, how's this going to work and how's this going to affect me? With regard to the stakeholder meetings, I really can't, we haven't planned what that outreach process will look like. There are going to be a significant number of meetings because Arizona is starting from scratch and doesn't have an existing program. I think we have a lot more questions to answer than Florida may. So ultimately, I would say a dozen or more stakeholder meetings are in our future.
Okay, and Trevor, I wanted to go back to something you said. You said the rules are different for the states and the feds under the current 404. You said EPA can object to a Corps permit, but they can't prevent them from issuing it. But EPA can stop a state from giving a permit or prevent them from giving a permit. So this won't change. This fed to fed and fed to state relationship, that won't change if you assume 404 on the state level, will it?
It won't. I will point out that we have, other federal programs that we regulate or that we have primacy over, specifically, Clean Air Act permitting, the NIPSEA's permitting, where it's the same situation where EPA objections are a possibility. We have a good relationship with our EPA region, and we try to work through any of those issues. There have been very few objections in the state of Arizona to this point, but we would expect under 404 that as we watch the Corps and EPA interact, there's less of agreement oftentimes between them on specific projects. We do believe, though, that the way to address that at this time is we have a favorable environment for orchestrating the memorandum of agreement with EPA to be able to clearly delineate when those objections occur, how we're going to try to resolve them. But yeah, us assuming the program actually creates the problem in a bigger way from that federal to state relationship.
Mm-hmm. And Trevor, also, how much staff do you anticipate that you'll have to hire new staff to write review permits? Is there any way to anticipate that now, or?
The way we've anticipated that right now is watching what the Corps does. Obviously, we believe that we're going to do things a little bit different than the local Corps office. The local Corps office currently has 10 full-time employees. Based on my interaction with the Assumable Waters Subcommittee, my personal opinion is that Arizona should be able to assume all of its waters except for the Colorado River, which is the only Rivers and Harbors Act Section 10 water in the state. And if that's the case, the Corps would keep the Colorado River and the tribal waters, which means they would still have about 1.5 FTE. So we're looking at about 8.5 to 9 full-time employees with all of the work and stuff that they do going into the program.
And then was the idea to cover those employees, to pay for them by charging permit fees, increased permit fees?
Correct. It would be a fee-for-service model is what we call it, yeah.
Okay. And then, John, you mentioned that there was a disconnect between the federal and state exemptions. Could you explain a little bit more about that?
Yes. So what we saw, one of the big exemptions was an ag exemption, agricultural exemption, that under the Fed process, under 404 as it exists, it has to be an existing agricultural use, and if you change it to a new agricultural use, the exemption no longer applies, and you have to get a 404 permit. Whereas in our state ERP wetland program, we don't have that distinction. We have an agricultural exemption, and if you change the use, for example, plant a new crop, you don't lose your exemption. So we had to have language in our proposed bill that was flagging the issue of, the state or the federal exemptions will have to apply to the 404 component of a permit, and the state exemptions apply to the state side of the permit. Now it is a disconnect, so it's just something I wanted to flag that everyone needs to consider. But given the fact, we've had that quote, disconnect, unquote, in the state of Florida for more than a decade, we already know how it actually works in operation. But it's one of those hiccups that if you don't catch those exemption differences, if you already have a wetland program, you could get through a legislative session and then realize you need another fix before you submit your package.
Okay, and I just wanted to open it up to ask you all if you had any questions for each other or other final comments before we finish the webinar.
No questions for John directly, but John, like I mentioned the other day, I would love to sit down and learn from you as far as the hurdles and how you're trying to solve them, to see what ADEQ and Arizona can use from the things that you've learned.
And no, and I appreciate that, and we are happily willing to reach out to anybody that wants to reach out and talk to us, because I would clearly say, obviously, we aren't perfect in doing it, but if I can help anybody avoid any stumbling blocks or make it easier, please use me as a resource. And if anybody else is looking at it, I'm sure there's probably something we can learn from you too. We're on a pretty accelerated time frame, so we'd love to keep the dialogue open with anybody that's interested.
Okay, thank you both, John Truitt and Trevor Bajori, for sharing your expertise with us today. And thanks to our listeners for joining in. And I want to remind everybody that a link to the webinar recording will be sent to you in the next few days. And also, if you had any trouble downloading the handout, you can just email me and I can email you the handout. And there was only one, there was a few documents, but it was all in one PDF. So with that, I'd just like to thank you all for joining us today, and this is the end of the webinar. I'll just leave that slide up for a few minutes in case anybody wanted to get my email and contact information. So thank you all, and have a great day.